Patriots, we have explosive developments in the pistol brace saga, and what's happening right now is going to shock you. The Trump DOJ just dropped their appeal of the nationwide block on the ATF's pistol brace rule. That's the good news. But here, the problem. Gun Owners of America and the state of Texas just exposed what might be the ATF sneaky backdoor plan to still regulate your pistol braces as short-barreled rifles. This is not over. In fact, the battle is just heating up. GOA and Texas Attorney General Ken Paxton are demanding a permanent injunction to stop the ATF once and for all. And the court just agreed to hear their arguments. Before we expose this entire situation, smash that subscribe button and hit the bell. We're at 600,000 subscribers and pushing toward 1 million. Let's show the ATF and anti-gun bureaucrats that we're not backing down. Alright, buckle up because this story has more twists than a legal thriller. The background. Biden's pistol brace attack. Let me take you back to where this all started because understanding the timeline is critical to understanding why what's happening now is so important. Back during the Biden administration, the ATF, under massive pressure from gun control advocates, decided to target one of the most popular firearm accessories in America, the pistol brace. For those who might not know, a pistol brace is a stabilizing device that attaches to R-style pistols and large-format pistols. It was originally designed to help disabled shooters and people with limited mobility stabilize their firearms. Millions of Americans own pistol braces. We're talking about one of the most commonly owned firearm accessories in the country. But the Biden ATF decided that if you put a brace on your pistol, boom, your pistol magically becomes a short-barreled rifle under the National Firearms Act. That means you'd have to register it with the ATF, pay a $200 tax stamp per firearm, wait months for approval, face 10 years in federal prison if you don't comply. This was an outrageous overreach. The ATF essentially tried to turn millions of law-abiding gun owners into felons overnight. Gun rights organizations immediately fought back. Multiple lawsuits were filed across the country challenging this unconstitutional rule. In one of those cases, the Mock v. Garland lawsuit became the key battleground. The Mock lawsuit victory. In the Mock case, Federal District Judge Reed O'Connor in Texas reviewed the ATF's pistol brace rule and delivered a devastating blow to the Biden administration. Judge O'Connor ruled that the pistol brace rule violated the Administrative Procedure Act, essentially finding that the ATF didn't follow proper rulemaking procedures when they created this regulation. He issued a nationwide vacatur that means the rule was struck down across the entire country. This was a massive victory. Gun owners celebrated. Pistol braces were safe again. But the Biden ATF wasn't done. They immediately appealed Judge O'Connor's decision to the Fifth Circuit Court of Appeals. They wanted that nationwide block overturned so they could continue their crusade against pistol braces. A case sat in the Fifth Circuit for months, with gun owners waiting anxiously to see what would happen. Would the appeals court uphold the nationwide block? Or would they side with the ATF and allow the rule to go back into effect? Then November 2024 happened. President Trump won the election. And everything changed. The Trump DOJ drops the appeal. When the Trump administration took control in January 2025, one of their first major moves on gun rights was dealing with the pistol brace appeals pending in federal courts. The Trump DOJ reviewed the Fifth Circuit appeal in the Mock case and made a decision. They agreed with the plaintiffs to drop the appeal. They filed a stipulation with the Fifth Circuit stating that the government would no longer contest Judge O'Connor's nationwide block. They essentially admitted, you know what? The pistol brace rule is done. We're not defending it anymore. This meant Judge O'Connor's nationwide vacatur would go into FULL effect with nitrogen monoxide further appeals. The pistol brace rule was dead. Gun owners across America celebrated. Social media exploded with people posting pictures of their brace pistols. Manufacturers started ramping up production again. It seemed like the nightmare was over. But here's where things get complicated and potentially dangerous. By dropping the appeal, the Trump DOJ secured an immediate win. Gun owners don't have to register their brace pistols. The ATF can't enforce the rule. That's all great news. But there's a strategic problem that GOA and Texas are now highlighting. We only have a district court ruling on procedural grounds. We don't have a circuit court or Supreme Court decision establishing strong precedent. And we don't have protection against the ATF using a different legal theory. The ATF sneaky backdoor plan, now here's where this story gets really concerning. And this is what GOA and Texas just exposed. Even after dropping the appeal, even after admitting the pistol brace rule is dead, the ATF has been making moves that suggest they still believe they can regulate pistol braces as short-barreled rifles. How? By claiming they don't need the rule, they can do it based purely on the statutory text of the National Firearms Act. Let me explain this crucial distinction. The rule that was struck down was the ATF's formal regulation with specific criteria for determining when a braced pistol becomes an SBR. That rule required notice and comment rulemaking under the Administrative Procedure Act, but the NFA itself, the statute passed by Congress in 1934, defines short-barreled rifles as rifles with barrels under 16 inches. The ATF is now suggesting that they can interpret that statutory definition to include brace pistols without needing a formal rule. In other words, we don't need the pistol brace rule anymore. We'll just say that our interpretation of the NFA statute means brace pistols are SBRs, and there's nothing stopping us. This is exactly what GOA and Texas are warning about. They've documented instances where ATF personnel have suggested this exact approach after the rule was struck down. Think about how dangerous this is. If the ATF can circumvent the courts by simply saying, "We're not enforcing the rule, we're just enforcing our interpretation of the statute," then every victory in court becomes meaningless. GOA and Texas fight back. Gun owners of America and Texas. Attorney General Ken Paxton saw this coming from a mile away. While other plaintiffs were agreeing to dismiss their cases as moot now that the Trump DOJ dropped the appeal, GOA and Texas said, "Wait a minute, this case is not moot. We need permanent protection." They filed a critical status report with the court arguing that their lawsuit should not be dismissed. Instead, they want to move forward and obtain a permanent injunction against the ATF. Here's what GOA stated in their filing, and this is incredibly important. Subsequent activities by defendants raised serious questions and doubts about their willingness to comply with this or any other court's ruling. The rule was vacated on procedural grounds, failure to constitute a logical outgrowth of a proposed rule, not a rejection of defendants' underlying statutory interpretation. They continued, without injunctive relief, defendants are in a position to simulate enforcement of the rule merely by reference to the underlying statutory scheme. Without a permanent injunction, the risk to plaintiffs caused by defendants' flawed legal theories actually remains. Do you see what they're saying? The ATF is playing a shell game. They're saying, okay, the rule is gone, while keeping the door open to enforce the exact same interpretation through a different legal mechanism. GOA and Texas want a permanent injunction that says, the ATF's interpretation that brace pistols are short-barreled rifles is wrong, and you are permanently blocked from enforcing that interpretation, whether through a rule, through statutory interpretation, or through any other method. This would provide real, lasting protection, not just a temporary victory that could be reversed by the next administration. The court's response, and here's the great news, the court is taking GOA and Texas seriously. Instead of just dismissing the case like other pistol brace lawsuits, the judge issued an order allowing full briefing on whether this case should be declared moot or whether a permanent injunction should be granted. The court has ordered the following schedule. First, the ATF and DOJ must file a motion to dismiss arguing why they believe this case should be found moot. They'll have to explain their position on whether they can still regulate brace pistols based on statutory interpretation. Second, GOA and Texas will file their response explaining why the case is not moot and why a permanent injunction is necessary to protect gun owners. Third, the court will review both sides' arguments and make a decision. This is exactly what we needed. The court isn't just rubber stamping dismissals. They're taking the long-term implications seriously. Now, here's what's going to be fascinating. How will the Trump DOJ respond? The Trump administration has been somewhat inconsistent on Second Amendment issues. Sometimes they've been strong supporters of gun rights. Other times they've taken more cautious positions. Attorney General Pam Bondi is still relatively new in her role, and we haven't seen a clear pattern yet. Will the Trump DOJ agree with GOA and Texas that a permanent injunction is needed? Argue that the case is moot and should be dismissed? Take some middle position? Their response will tell us a lot about where this administration really stands on protecting gun rights long-term versus just securing short-term political wins. Why this matters for every gun owner. Let me explain why this case is absolutely critical for every gun owner in America, even if you do own a pistol brace. First, the precedent problem. Right now, the only court ruling we have against the pistol brace rule is from District Judge O'Connor, based on Administrative Procedure Act violations. That's a narrow ruling on a procedural issue. A future anti-gun administration could easily say, okay, we'll follow proper IPA procedures this time. We'll do notice and comment rulemaking correctly, and we'll issue a new pistol brace rule that fixes the procedural problems without a permanent injunction on the merits, without a ruling that says the ATF's interpretation is constitutionally and statutorily wrong. There's nothing stopping this from happening. GOA and Texas want a ruling that says brace pistols are not short-barreled rifles under the MFA, period. The ATF's interpretation is incorrect, and they are permanently barred from enforcing it. That would provide real protection. Second, the statutory interpretation loophole. If the ATF can enforce regulations based purely on their interpretation of statutes without going through rulemaking, that's a dangerous precedent for all gun owners. Think about all the other areas where the ATF could use this approach. Forced reset triggers? Our interpretation of the statute says they're machine guns. 80% receivers? Our interpretation says they're firearms. Certain ammunition types? Our interpretation says they're armor-piercing suppressors. Our interpretation of NFA says they can be heavily restricted. If we let the ATF bypass the rulemaking process by claiming statutory interpretation, we've handed them unlimited power to regulate firearms without any meaningful judicial oversight. Third, the future administration threat. Look, we're fortunate right now to have an administration that's generally more favorable to gun rights. But what about 2028, 2032? If we don't secure permanent injunctions now, while we have the opportunity, all these victories could evaporate the moment a Democrat wins the White House again. A permanent injunction survives changes in administration. It provides lasting protection regardless of who's in power. Fourth, the broader Second Amendment battle. This case is part of a larger war over how the Second Amendment is interpreted and applied. Every victory matters. Every strong precedent matters. If we can get a court to rule that the ATF's interpretation of brace pistols as SBRs is wrong, that strengthens the argument that the ATF is regularly exceeding its statutory authority. It builds momentum for challenging other ATF overreach. It creates case law that future courts will have to consider. It shifts the legal landscape in our favor. The risks of settling too quickly now. I want to address something that has been debated in the gun rights community. Did the Trump DOJ make a mistake by agreeing to drop these appeals so quickly? On one hand, dropping the appeals gave us immediate relief. Gun owners don't have to worry about the pistol brace rule right now. That's valuable. But on the other hand, we lost opportunities for stronger precedents. If the Fifth Circuit had ruled in favor of gun rights, we'd have a circuit court precedent, much stronger than just a district court ruling. If the case had gone to the Supreme Court and we'd won, we'd have the strongest possible precedent protecting not just pistol braces, but potentially limiting ATF authority more broadly. By settling early, we got a quick win, but potentially sacrificed long-term gains. This is the strategic debate happening right now among gun rights organizations. Take the immediate victory and declare success? Or keep fighting for permanent, comprehensive protections even if it means more litigation? GOA and Texas have clearly chosen the latter approach. They're saying, we're not satisfied with a temporary truce. We want a permanent victory that protects gun owners for decades to come. And honestly, I think they're right. We've seen this pattern before where the ATF backs down temporarily when they face strong opposition, only to come back years later with a slightly different approach. Remember how long they flip-flopped on pistol brace interpretations before finally issuing the rule? Without permanent injunctions, we're just playing whack-a-mole with ATF overreach. What happens next? So here's what we're watching for in the coming weeks and months. January 2025. The ATF and Trump DOJ must file their motion to dismiss, arguing that the case is moot. This will reveal their true position on whether they believe they can still regulate braced pistols through statutory interpretation. February 2025. GOA and Texas will file their response explaining why permanent injunctive relief is necessary. Expect them to cite specific examples of post-rule ATF enforcement attempts. Spring 2025. The court will rule on whether the case is moot or whether briefing should continue toward a permanent injunction decision. If the court allows the case to proceed, we could see full merits briefing on the Second Amendment implications, arguments about the scope of a TF authority under the NFA, potential hearings or oral arguments eventually, a ruling on whether a permanent injunction should be granted. This could take several months to over a year to fully resolve. But here's what's crucial. If GOA and Texas succeed in getting a permanent injunction, it would be a landmark victory. It would establish clear precedent that the ATF cannot treat braced pistols as SBRs, not through rules, not through statutory interpretation, not through any mechanism. The Trump administration's dilemma. The Trump DOJ now faces an interesting dilemma in how they respond to GOA arguments. If they agree with GOA and Texas and support a permanent injunction, it shows they're serious about long-term Second Amendment protection. It demonstrates they're not just playing politics for short-term wins, but it also might force them to admit that the ATF, under their own administration, could potentially misuse statutory interpretation to regulate firearms, which could be politically awkward. If they oppose GOA and Texas and argue for dismissal, it raises serious questions about their commitment to gun rights. Why would a pro-gun administration oppose getting a permanent injunction that protects gun owners? If they take a middle position, maybe supporting some relief but not a full permanent injunction, it shows they're trying to balance competing interests. But it might not provide the comprehensive protection gun owners need. Attorney General Pam Bondi and the Trump DOJ lawyers working on this case have a critical decision to make. Their response will be closely watched by gun rights advocates across the country. What gun owners should do if you a gun owner, especially if you own pistol braces, here's what you need to do. First, stay informed about this case. Follow GOA, follow Second Amendment channels, watch for updates. This case could have massive implications. Second, support the legal organizations fighting these battles. GOA, FPC, SAF, these groups need funding to keep up the fight. Consider becoming a member or making a donation. Third, contact your representatives. Let them know you support permanent protections for pistol braces and limits on a TF authority. Fourth, don't assume the battle is over just because the rule was struck down. As we've explained, there are still threats that need to be addressed. Fifth, if you own braced pistols, understand the current legal status. Right now, they're not regulated as SBRs thanks to the nationwide block, but stay alert for any future developments. Closing, all right, Patriots, that's the complete breakdown of this critical pistol brace case and why GOA and Texas are fighting for a permanent injunction. To summarize, Trump DOJ dropped the pistol brace rule appeal, immediate victory. But GOA and Texas warned the ATF might use statutory interpretation as a backdoor. They're demanding a permanent injunction to block ALL forms of braced pistol regulation. The court agreed to hear full briefing. This is huge. Trump DOJ must respond in January. Their position will reveal a lot. This case could provide lasting protection for millions of gun owners, or it could be dismissed as moot, leaving the door open for future attacks. The stakes couldn't be higher. If you found this breakdown valuable, smash that like button. Share this with every gun owner you know. Subscribe and hit the notification bell for updates as this case develops. Comment below. Do you think GOA and Texas are right to keep fighting for a permanent injunction? Or should gun rights groups accept the victory and move on? I want to hear your thoughts. Remember, eternal vigilance is the price of liberty. We can't let our guard down just because we won one battle. The war for the Second Amendment continues.